I want to take a little bit of time and discuss what a mediation is in family law. A lot of times people see stuff on TV and really don't know what to expect because it's really a foreign part of the case that people know that exists but don't really know what it entails. So there are two varieties that we see most often in Oklahoma. There is the early settlement mediation program, which is the free version that's paid for by the state. And then there's also the private mediators that you can hire that are more experts in their field that come with a cost, often more than the attorney cost, but is a opportunity to get somebody with specialized knowledge. It depends on the needs of the case. If the case is very contentious and there's not a lot of people willing to give much, the paid for mediator is a great asset because they can work together and start to narrow down the issues. The early settlement mediation does a fantastic job, but they are not attorneys and are often handicapped by what they can do for us if we're not willing to make a negotiated effort to find a middle ground. Most of the time, if I schedule an early settlement mediation, it goes well, but we get to a stopping point, and then that's what it is. It's an opportunity to narrow down some of the issues and to find the remaining things that the judge needs to decide. In some scenarios, we do early settlement mediation because we know that there's not much of an agreement there, but it's court ordered. We don't need to pay for a mediator and to do the prep and to figure out what all's going on and to show up when we know that there's not going to be a lot of give. However, when we do get to a successful negotiated path forward, it will end the case at that point as long as everybody's willing to agree to what we decided on that day in the mediation and we can put it on paper and turn it into the judge. The mediation itself is not binding on the court process. You get a memorandum of the mediation that is presented to the judge as far as what we agreed on and what we don't, and can kind of move forward where they have some more understanding about what we need to do and how the case is going to proceed moving forward. But nothing is binding until the judge signs it. That's a very important point because negotiation in itself is only as successful as both parties are willing to make it. A lot of times in big civil cases, we've shown up to mediations. They have an annuity officer or the bank there because they know they're going to make a settlement offer and want to put that money to use. If we show up in, let's say, a child custody case and neither one of the parties is willing to give, we know it's going to be a short day. So it really just depends on the needs of the case. However, how we structure these things can look a couple of different ways as well. There are mediations where there are two separate rooms and each party has their own room. There's party A and then there's party B, and you don't see each other. There's often mediations, which is often the early settlement mediation, if there's not a necessary need as far as violence or domestic issues or VPOs in place, you might be sitting in the same room across the table with your attorney. If that's the case, then you have an opportunity to explain what your wishes and desires are. So does the other side. And then you start having a little bit of back and forth about what you're willing to give up and what you're not. These are tough situations to deal with because essentially you're staring at the person that you don't get along with. However, it does put a lot of pressure on both sides to either one, act appropriately, or two, show that the other person is acting out. And that does give us a little bit of leverage, knowing what is important, what is not, and some of the things that they don't portray on paper as being super important to them. Now, a paid for mediator, you're almost always in two separate rooms where the mediator goes back and forth and tries to work on the middle ground as quickly and easily as possible. If that's the case, you oftentimes will have the mediator kind of play both sides a little bit to try to loosen everybody up, kind of see what's good and what's not. But depending on the mediator's negotiation skills is whether they can take your argument and portray it to the other side as well as you feel like it should be. This is often something that is unnerving to give all your wish list. The lady walks out of the room and then an hour later comes back and says, okay, here's the offer. Well, what did you guys talk about? That's not really the way this works. It's more of a private situation where she is the intermediary, that's a third party that's not invested in the case, that's willing to work together with us to where we can do it. Now, what does a mediation look like? Well, typically it's scheduled for 4 hours. Early settlement, for example, it's either a morning or an afternoon. A private mediator can go as long as necessary. I've had them go, into the night, and everybody was willing to stay because we were going to get a deal done. I've also had them be very short, very direct, but oftentimes you want to plan for 4 hours. That is a concern when you talk about, like, you've obviously got to take off work, you've got to get there, you also have to pay your attorney to be there. So before we get into the nitty gritty of what this costs and how everything goes, we need to make sure that either side of the coin, for the early settlement or the private paid, is worth your time and money, because you don't want to have to pay a mediator for 4 hours if they have a minimum regardless of being there, and you're there for 15 minutes, for example. Whereas the early settlement, you walk in, you say, we're not agreeing to anything, the day's over, we move on. It really just depends on the needs of the case. I would look at mediation as a necessary part of the case, because for me, as somebody trying to litigate this for you, I can find out a lot about the posture of the client, the posture of the attorney, how that individual deals with their attorney, what kind of relationship they have, and whether they're telling all the truth or not. Because sometimes people don't. We are in a business of trying to portray that person or the case in the best way possible. Oftentimes, if we're in mediation at that point, it means we're not in agreement. So finding out what's real and what's not is incredibly valuable to us. However, the ending of the case and the potential of stopping all of the proceedings from that point forward is probably the biggest incentive there is. As long as we can get there, everybody's willing to make those steps and take it down, it will at least shorten the time at trial, the time necessary to put documents and evidence together, and then we can look at a smooth, streamlined path forward where we know exactly what to get. Now, you will have questions about this. I understand that. This is a 30,000-foot view of what mediation is and what your individual case is going to be like. I want you to have some understanding about what it is, what we do, and what this looks like, and then we'll talk a lot more about it. This is something that every individual case has its individual needs and will be approached custom to the needs of that case. So we will talk about it individually, we'll look at it, but this is kind of, like I said, the overview and the understanding of what some of these terms are and the difference between the free and paid for versions and where we go from there.